Hey everybody, it's Laura here on YouTube, TheRealLauraB, and also on Twitter. I am here today with a new video about a book that is apparently being spread, a book tour going around by Jen Robinson. She is a barrister at Doherty Street in the UK. She was the personal lawyer for Amber Heard on various times, but I know for the Depp v. Sun case, or Depp v. NGN. She represented Amber Heard and she was involved. She has come out with a book along with someone else, and she has a chapter dedicated to the Depp v. Sun case, talking about Amber's involvement. And I find it very interesting, and the fact that it's in direct opposition of what a UK judge, Judge Nicklin, ruled on. So I wanted to bring it to you and the information I have on it. So this is going to be a different deep dive because we're going to go back to the Sun trial, and we're going to be presenting something that many people have never seen, and that's Johnny Depp's first actual witness statement. And if you go to Nick Walsh's site, you'll see that the court started with his second. This is where his first witness statement came in. So hang in there and let's get started.
Hi, I'm Laura, also known as TheRealLauraB from Twitter, and now here on YouTube. I'm a researcher, new wave internet media, and commentator. I'm not a lawyer nor offering any legal advice. Join me on a journey to review the world of celebrity lawsuits and current events. Let's get started.
Hey again. So just as a quick startup, I just came from a kerfuffle at Twitter where someone has created an account to imposter me. Thank you everybody who rallied very quickly and had them suspended. I only have two accounts. I have my original account that's been around since, is it 2016? And that's Laura Bacov, and it's titled TheRealLauraB. Why did I come up with that name? Well, this is what I'll quick explain. So during coverage of all the trial and pre-trial since 2016, I was constantly being attacked and criticized and dogpiled on because I was bringing the truth. They didn't like I was bringing the truth. They didn't like I was bringing court documents that they couldn't argue with. So I was constantly getting dogpiled. And right around the time of the court in UK, I can't remember if it was before or after, I did get suspended, and I made a new account, TheRealLauraB1. No, actually, I didn't make it until after I got my account reinstated. I fought very hard, and I got my account reinstated, and then I realized this could happen again, and I'd better have a second account. So I do have TheRealLauraB1. I was reinstated, and when that happened, people kept asking me, is this really you? Is this really you? I'm like, yeah, I'm really back. I'm really back. And I said it so many times that that's why I changed my account to TheRealLauraB. So people knew that it was really me and I was really back. And then I created the second one. So now people know when I put in my profile that I do have two accounts. The other one's private. I don't use it. It's just there. And it was, there for an emergency. So that's that. I do not ask people for PayPals. I have it attached to my YouTube. I was impostered another time where people stole money. So please be very careful. Check the accounts, check the profiles, go to places you can trust if anybody's asking for money or suggesting for money. I did try to get verified. Twitter has made it very hard. I don't qualify as an influencer. I don't qualify as an activist, and I have not had enough articles that I've written personally as a freelance journalist, or that have been written about me. Tug obviously has had a ton, and good for him getting his blue check. Good for him. But now let's get back into this story. So we're going back to the Depp versus NGN trial when it was first starting up and gearing up, and he filed and they started discovery. Jen Robinson represented Amber Heard as her personal attorney. And what I will find, and I'll be presenting back actually in another video with Melanie Inglis, proof that Amber's attorneys in the US were sending discovery information to Jen Robinson because Jen got Melanie's declaration, US declaration, that they then tried to convert into a UK statement. So she was definitely receiving discovery information. Anyway, she has now written a book, and let's go to her page here. This is her official page. She's a barrister at the Doherty Street, and that's in the UK. Views are only her own. She has written a book, How Many More Women? It's a conversation with a brilliant woman from Australia. Well, not so much. So she's on a book tour. So this is her. She represented Julian Assange. That's what she's mostly known for. Here it is. Hello, Melbourne. In a few hours, we'll be in convo with this incredible Clementine Ford. That's an important name. I'll be bringing her up for the launch of our book, Jen Robinson. And Kina Yoshida is the co-writer, and this is a conversation with Clementine Ford. And this is where I got my information on the book, from Clementine's post, because the book is not out or available for me to go by. So I have to go by what she's reporting. So they're on a book tour, and again, this book is about how the law is against women in divorces or DV or TROs. And to a certain extent, I understand that. But she's blatantly misreported based on what I see Clementine claiming and what Judge Nicklin ruled on. And that's what's important for me to be looking at today. So anyway, this is the book. It's How Many More Women, The Silencing of Women by the Law and How to Stop It. It is not out until February 2023, so I could not get it to use it directly. You can pre-order it. Okay, so there's no reviews on it, but that's where it is. This is Clementine Ford, and this is what got it all started. This was shared to me. She's an author, so she's been interviewing, and she was quite active in the Amber Heard support. But this is what she's put out there from this book that I found so interesting.
Another really interesting detail in this chapter is because Amber Heard had signed an NDA during the divorce proceedings with Johnny Depp. And also it's important to note that aside from her restraining order against him, she had never mentioned him publicly. She'd never spoken about the abuse that he subjected her to. She did write an article about being a survivor, but he was not named in it.
Excuse me. Girl Gaze? People Magazine? I mean, she's been working for Harry Walker's speaking agency, but yeah, sure. She never spoke about it ever.
And because she had signed that NDA, she was technically prevented from giving evidence in the UK libel case against the Sun newspaper, the case that John Depp brought against the Sun newspaper, that she needed to get around the NDA to offer evidence to support the court. But she didn't really want to. It was essentially the same situation as Erin Jean Norval here, where the Daily Telegraph published her story without asking her, and she was forced to speak against Geoffrey Rush publicly.
Okay, yeah. We know she didn't want to, for sure. Did not want to testify, but I will agree that Amber Heard did not want to testify. And when this was all going down, I've been following it very closely. There was an article that came out. Johnny's witness statement was released first. And he talks about everything that was happening. And what I found interesting, a lot of this argument back and forth about Amber Heard testifying happened before her op-ed was written. Now, Johnny was not stopping her from testifying. Amber Heard did not want to testify. And in doing so, she was hoping one of two things would happen. Either the Daily Mail would get it dismissed or that Johnny Depp would drop that. And that's what's so important, because this information is blatantly wrong. And we're going to cover that. Let's finish here.
So to put this in terms that I understand, not being a lawyer, because Amber Heard had signed an NDA at the occasion of their divorce, and then the Sun newspaper had then printed an article calling him a wife beater, which she had never said publicly. All she had was a restraining order against
She had the People magazine. She said publicly, besides the TRO.
Him, but she'd never labeled that allegation against him publicly. He brought that libel case against the Sun, but he refused to release her from her NDA, which would enable her to testify in that case, which meant that if she hadn't fought against it for the right to be able to testify, he could have won on the basis of it being just the newspaper's word against his, which means that she could have then been publicly branded a liar because he would have won his libel case despite the fact that he refused to allow her to leave the NDA in order to testify. And had she not fought for the right to do it and just done it anyway, he could have sued her in American courts for being in breach of that NDA.
Now, I understand that this is a problem for women. I do. But that's not what happened in this case. And that's what's important, that when these claims started coming out and coming to Johnny from the Sun saying, hey, you're refusing to allow her to testify, therefore we're going to get this dismissed. He's like, no, I have nothing to do with that. And I found it all very interesting because I'm going to go to Johnny's first witness statement and he's going to talk about this, but he's also going to reference dates They're going to be well before Amber Heard wrote her op-ed. And I think, again, these all play into it, that she was trying to get Johnny to drop this. So this was filed January 22nd. This is John C. Depp's first UK witness statement. It was made public through TMZ. It was not made public on Nick Wallace's site. It was not used in the court because this was in response to a pretrial motion that the Sun, or NGN, filed. I am the claimant in these proceedings. Unless stated otherwise, the facts and matters referred to in this witness statement are within my own knowledge and true, or are true to the best of my knowledge, information, and belief. I make this witness statement, and this is important, in response to defendants' applications dated 29 November 2018, prior to her op-ed, which seeks a stay of proceedings until such time as I confirm in writing to my former wife, Miss Amber Heard, who is not a party to these proceedings, or her legal representatives, that I shall not at any time seek to assert against Miss Heard any claim in any jurisdiction or right to restitution, damages, cost, or other relief or remedy of any kind in respect of A, any disclosure or communication that may be made to the defendants or their legal representatives for the purpose of these procedures, and B, any evidence that she may give, whether orally or in writing, for the purpose of these proceedings. For the purpose of preparing this witness statement, I have read the witness statement of Louis TheRealLauraB, dated November 29th. It's in exhibits. We don't have the exhibits, I'm sorry, and refer to where they are appropriate. There is now produced to me and marked Exhibit JCD1, a paginated bundle of true copy documents referred to as witness statement, references to page numbers, and we don't have any of that. Background. These proceedings related to an article published by the defendant, which appeared online April 27, 2018, and in hard copy on April 28, 2018, together called The Article. The copy of the article is pages 1 through 5. As set out in the particulars of the claim, paragraph 10, the article includes words which I contend meant and were understood to mean that I was guilty on overwhelming evidence of serious DV against Miss Heard, causing significant injury and leading her to fear for her life. The article further suggested that I was constrained to pay no less than £5 million, $7 million, to compensate Miss Heard for her alleged behavior, that my actions resulted in me being subjected to a continuing court restraining order, and that for that reason I am not fit to work in the film industry. That is how it came across in the article. I issued proceedings against the defendants, that's NGN, on June 1st, 2018, claiming for damages for libel and an injunction. The defendants filed their defense on July 11th, and a copy of its pages are attached. Again, we don't have any of the exhibits. The defendants rely on the defense of truth in relation to the meaning the claimant, his wife, Amber Heard. I have to be careful with YouTube. Mr. C, I'm going to call him, accepts in his witness statement on paragraph 5, the defense has pleaded on the basis of information in U.S. court documents, which is strictly the TRO. That's all that there is. Because I don't think they were publicly made the divorce settlement. The only public documents they had were the TRO that was released. And again, they did not interview Mr. Depp nor Miss Heard. One of the allegations made by Miss Heard in those documents relates to an alleged incident on May 21. As a truth defense was put on the record, I was obliged to put in a reply addressing the factual allegations relied on by the defendants in their defense. As more fully set out in the reply, the two police officers who attended the scene of the incident alleged by Miss Heard on May 21, shortly after the incident occurred, and who had released an exculpatory public statement with the first defendant had reported. In other words, the police came out and said it didn't happen, and the Sun, the first defendant, NGN, they reported what the police said, so they knew, provided two separate depositions describing what they saw, stating that they found there were no injuries or bruisings or swelling to Miss Heard's face, and indeed the scene bore no resemblance to that described by each of Miss Heard and her friend under oath. Despite Miss Heard's sworn deposition to the contrary, Miss Heard had told them to their faces that nothing had happened and made no mention of an assault. She said she was not injured and refused medical treatment. In particular, I refer to this paragraph of my reply. The phone did not miss Heard on the face or elsewhere, nor did the claimant pull Miss Heard's hair or strike her or grab her face or touch her. Two police officers who attended the apartment directly after the alleged incident and interviewed Miss Heard twice in good light saw no injuries or bruising or swelling to Miss Heard's face or elsewhere. When one of the officers asked Miss Heard what had happened, she responded, "Nothing." When Miss Heard asked if she was hurt, she shook her head. Miss Heard did not say to the officers she had been assaulted, and when asked if she had been injured in any way, she said she wasn't injured and refused medical treatment. Miss Heard said she did not want to make a police report and there was nothing wrong. So this is what was publicly available to the Sun when they wrote the article. This is what Johnny's stating. Further, as stated in this paragraph of the reply, which we don't have, both of these officers subsequently confirmed their evidence to this effect in separate depositions, copies of which they attached. In the premises, if and to the extent that Ms. Pennington subsequently took a photograph of Ms. Heard's face, as pleaded in the paragraph, which is not admitted, it was not a photograph of any injury caused by the claimant. In the subsequent proceedings brought by Ms. Heard, hard copy photographs were put in evidence, but neither the original images nor the associated metadata were produced. And we knew that. We saw that in the Fairfax trial, which was why a lot of the metadata was not allowed. We also saw a lot more in the States. This is hindsight, sadly. This is what happened before the NGN trial, even the UK trial even came to happen. This is highly significant and exculpatory evidence that has been ignored by the defendants to my detriment. The defendants appear to have made no attempt to check the facts prior to publication or to ascertain whether there was any basis on which they could defend an action. If they did so, they must have made a positive decision to present a totally one-sided picture, leaving out my side of the story and pretending it either did not exist or was not worth considering. Further, in the event that this matter goes to trial, I will rely, amongst other things, on the following evidence to support my position in respect of the factual allegations by the defendants of their defense. So we have Sean Betts, and we know what he had to say, that he had been there. What we don't have, that we had not heard before, was the declaration of Jerry Judge, and I'll jump to that because I don't want to overwhelm with duplicate information. I was with Johnny throughout the day on May 21st, and I escorted him along with Sean Bett to his down loft. I did not observe Johnny drink any alcohol or take any drugs that day. He was sober in all respects when we arrived at the loft between approximately 7 and 7:30, about 30 minutes or less. Sean and I entered the loft upon hearing raised voices, although Amber's chiefly from within. I did not observe Johnny touch or even approach Amber. In fact, they remained approximately 10 feet during the period of time that I observed them. They were 10 feet apart, which Raquel also had stated. I did not observe Johnny break anything, including wine glasses or bottles in the loft or outside the loft or the hallway. I did observe 2 tall glasses with wine in them in the loft, but they were intact. I did not observe shattered glass anywhere in the loft. We had declarations from the Eastern Columbia building people, and we know that they testified. So let's keep going. Trinity again testified that she saw no makeup and saw no injuries. Same with Cornelius Harrell. So this is what's important. I'm sticking to specifically what Clementine is claiming inside Jen Robinson's book, and that's about the NDA. So that's what I'm concentrating on here. As referred to in paragraph 8 of Mr. C's witness statement, I was married to Miss Heard from February 2015 to January 27th, which 27th was when they legally signed the divorce agreement. In May, Miss Heard filed for divorce. At the same time, Miss Heard sought a DVRO against me. It was temporary. It wasn't permanent, although they apparently reported like it was permanent. It was in Los Angeles, granted a temporary restraining order on an ex parte basis, which means he didn't even have knowledge of it. And we saw Laura Wasser testify that. I intended to challenge the restraining order in open court, but before I was able to do so, Miss Heard and I, came to an agreement in August 2016, which dealt with all the terms of our divorce settlement, including a financial settlement in respect of the divorce. Subsequently, the marriage was dissolved January 13, 2017. The terms of the agreement are set out in a stipulated judgment of dissolution of marriage exhibited to Mr. C. We've seen a copy of it. Amber Heard attached it to her April 11, 2019 filing, which included her declaration. As recorded, paragraph 8.1 of the agreement, Ms. Heard dismissed her request for domestic violence restraining orders with prejudice. They could never be brought again. On August 16th, the same paragraph recurs that both Ms. Heard and I agreed that neither of us was the prevailing party. The first defendant knew about this fact prior to publication because it was reported in an article. So they knew about it. They knew it had been, that there was no prevailing party. Nobody won. And they didn't show that sign in the article, the Sun's article. Paragraph 8.3 of the agreement records the agreement that neither I nor Ms. Heard would pursue civil actions against the other, including for libel, slander, or defamation for any reason in any jurisdiction for anything that occurred for the time period through and including the execution of the deal point memorandum on August 15, 16 memorandum. So again, her op-ed came out afterwards. Paragraph 8.4 of the agreement records that Ms. Heard had not filed a police report claiming any criminal wrongdoing on my part. It continues, Ms. Heard shall not be limited in any way with fully complying with any valid legal process or cooperating with any legal enforcement investigation. In the event that Ms. Heard is served with any valid legal process relating to any way to Mr. Depp and or his dissolution action, Ms. Heard shall notify Mr. Depp in writing within 48 hours of receipt of the legal process so that Mr. Depp may make any and all appropriate and legal objections to such process as he deems necessary. The confidentiality provisions are set out in paragraphs 20.1 through 4, and we have those. Relates to information on the internet and the media. Paragraph 20.3 records the agreement that neither party to the agreement will make or cause to be made any derogatory, disparaging, critical, or accusatory statements, either directly or indirectly, express or implied, oral or written, considering the other party, whether said statements are believed to be true or not. That provision has an express carve-out, except as required by law. Similarly, paragraph 20.4 provides the foregoing shall not be construed to enforce in a manner that was restricted disclosing party from responding truthfully in response to any inquiry required by legal process. Paragraph 21.6, this judgment shall be interpreted fairly and simply and not strictly for or against either party. Paragraph 21.15 of the agreement, this judgment and each of its provisions herein may not be altered, amended, terminated, modified, or waived in whole or in part, except by an instrument in writing executed by both the parties hereto with the same formality as the judgment or by further order of the court. Furthering, paragraph 21.16, judgment is executed and intended to be performed in the state of California, and the laws of the state of California shall govern its interpretation and effect. I believe, this is Johnny, I believe that the effect of these provisions, which were intended to conclude matters between Ms. Heard and I, cannot be construed to prevent me from defending myself from defamation by third parties, including bringing a libel action against a third party, and in the event that a truth defense is pleaded, giving evidence in those proceedings. So Johnny's saying, look, they've accused me of doing this in an article. They didn't say it was alleged. They didn't say she alleged. She didn't say he was accused. They concluded he did it. They concluded, and this is why he had to pay this fees. They concluded that it was a permanent TRO. So he says, look, I get to defend myself. A confidentiality agreement doesn't prevent me from defending myself against other people. It is also clear that Ms. Heard and I agreed that it would be the California court that would determine matters in relation to the agreement. I first know about defendant's position in relation to Ms. Heard was a letter dated August 30th, but not seen by my lawyers until December 5th from Brown George Ross. Ms. Heard's U.S. lawyers to my lawyers. This is before the op-ed was written, long before. A copy of their letter is on page 158. We don't have that in that letter, Brown George Ross stated, this is Eric George, this is her lawyer, stated that the defendant's lawyer had asked us to provide evidence in the libel action. So she knew, August 30th at least. She knew she was being asked to give testimony, provide evidence for the Sun in the UK action. The reply and the confidentiality provisions of the agreement were referred to, and the following request was made. In the light of the allegations you made in the UK proceedings, I am now asking that your client expressly release Ms. Heard from the confidentiality agreement in order to enable her to fully respond to your public accusations concerning Mr. Depp and Ms. Heard's relationship. As can be seen by the letter, a general release from the confidentiality agreement was sought. It was not confined to disclosures in these proceedings. She wanted the whole thing done and clear it all. Free reign, no more confidentiality agreement. She could write a book and say anything she wanted. She could disparage him. The whole point was that they were done and over with, but Mr. Depp has a right to defend himself, and he's saying that any confidentiality agreement should be confined to the disclosure in these proceedings only. This is very important, and this is what Jen Robinson's book apparently is not stating. I did not and do not believe I was under any obligation to respond to Ms. Heard's lawyers, as Ms. Heard is not a party to this proceeding. Nor did I believe and do not believe now that as a result of being libeled by NGN and the Sun, I should be forced to revisit the agreement or give Ms. Heard the wide release sought. On September 26th, this is Eric George, her lawyer, wrote again stating, "We can only infer that your continued silence on a matter which simply requires a yes or no is a refusal which your client does not wish to acknowledge, and as it exposes the inconsistency of his position. I believe this is both an unfair and inaccurate interpretation of my position." Copy of the emails. Look, Johnny is not suing Amber Heard. He's suing the Sun. And now this third party is coming in and says, hey, they want me to testify, so you need to release me. He's like, I'm dealing with the Sun's lawyers. If they have an issue with their witness, they need to be talking to me. On October 19, 2018, the solicitors acting for the Sun wrote to Brown Rudnick. That's who was representing Johnny in the UK at the time, although they were also representing him in the US. Copy of the letters attached. The letter referred to Eric George's letter of August 30th and stated inter alia that I had breached the terms of the agreement in 1, my pleadings, 2, in press statements, and that as a result, Ms. Heard must be released from the terms of the agreement. I do not accept that the pleadings amount to a breach of the agreement in relation to press statements. That is a matter between Ms. Heard and I, and again, I do not believe that I should be forced to address alleged breaches by me of agreement to which the Sun is not a party. As of October 19th, I had not given any indication that I would do anything to prevent Ms. Heard from giving evidence. My lawyers made that position clear in their response. October 26th, a copy of which is included, among other things, says, and again, these dates are important to me, all before the op-ed was written. Our client can hardly be criticized for defending herself against public accusations which threaten to destroy. Sorry, let me say that again. Our client can hardly be criticized for defending himself against public accusations which threaten to destroy his career and are totally false. In the case of the Sun newspaper, Mr. Wooten, it appears to be their intention that our client's career should be destroyed, since the thrust of the article sued on is to excoriate J.K. Rowling for standing behind the casting of our client in a film, instead of recasting another actor in the role. You suggest our client is guilty of abuse in the court's process, and he has done literally nothing to obstruct or impede or interfere with your client's defense of the action. Neither does he have intention to do so. Your clients must have expected to be able to prove their case before putting a defense of truth on the record. They cannot now do so. That has nothing whatsoever to do with our client, who we repeat has done literally nothing to obstruct, impede, or interfere with your client's defense of the action. So Amber Heard is claiming, I can't testify unless I'm released. They're saying, hey, if you were willing to make these statements without interviewing Ms. Heard or myself, you must have had something that you could have used without Ms. Heard. On November 5th, the Sun's lawyers wrote to my lawyers asserting that my lawyers had not replied to their question, namely whether I would now release Ms. Heard from her confidentiality obligations. In response, my lawyers repeated that I had done nothing to obstruct, impede, or interfere with the defendant's defense of the action, and that remains the position. It was not until service of the application that it became apparent that Ms. Heard's lawyers had advised the defendants that Ms. Heard is unwilling to give evidence without being released from the confidentiality proceedings. The whole thing she wants to be released from. The letter from, and I think it's from Eric George, her lawyer, is November 2018, and again, prior to the op-ed. Confidentiality provisions of the sort to which Ms. Heard agreed are intended to preclude one party's allegations against the other from reaching third parties. Inasmuch as Mr. Depp, by bringing suit against the Sun, has by definition involved a third party in his allegations against Ms. Heard, we endeavored to procure a limited confidentiality waiver to enable the court to adjudicate the merits of Mr. Depp's allegations. In keeping with policy underlying the judgment's confidentiality position, we sought a release only for this purpose and not for any subsidiary reasons, such as publicly discussing the incident described in Mr. Depp's particulars of claim. I regret that Mr. Depp refused to consent to our request. In the absence of such consent, we are unable to provide the court with Ms. Heard's testimony. Amber did not want to testify. In fact, again, to be Eric George's assertion that it had sought a limited confidentiality waiver was one more fiction. From that letter, it appears that Brown George Ross have failed to appreciate that there was no incident described by me in the particulars of the claim. It is the defendants who pleaded a case of truth, relying on a number of alleged incidents. As explained in paragraph 9 above, I was required to respond to those allegations by law and did so in reply. As to the letter from Miss Robinson dated November 26, 2018, so Miss Robinson is involved. She knows. She has knowledge now of what's been going on. Referenced in paragraph 32 of Mr. C's witness statement and exhibited, we don't have. I note that Miss Robinson simply repeats that Brown George Ross has made it clear that Miss Heard is unable to provide such evidence absence of consent of Mr. Depp because their divorce settlement includes strict confidentiality provisions. Miss Robinson then states that it is Miss Heard's U.S. counsel's opinion that both Miss Heard and I are prohibited from unilaterally giving evidence in the U.K. proceeding, and that a decision by either to do so without the other's consent would expose that party to additional legal proceedings in the U.S. to prove liability and damages for breach of contract. Insofar as this assertion relates to me, I do not believe that the agreement could fairly be interpreted as preventing me from giving evidence in the normal course of legal proceedings. I also do not believe that I should be forced by the defendants in these proceedings to express a view as to the effect of the agreement in relation to Miss Heard giving evidence. Miss Robinson repeats the inaccurate assertion that Miss Heard's lawyers had simply requested that she be released from the agreement for the sole purpose of giving evidence in these proceedings. As I've explained above, the original request related to or appeared to relate to a much broader general release. I note that Miss Robinson states that Miss Heard should not be required to go to the expense of obtaining a U.S. court order to release her from confidential obligations to be able to answer factual matters raised in these proceedings which have been brought by Mr. Depp at his initiative. In bringing these proceedings, Mr. Depp is calling into question the veracity of Miss Heard's account of domestic violence. Mr. Depp should not be permitted to use defamation proceedings in the UK to vindicate his reputation while holding Miss Heard to confidentiality proceedings to prevent her from answering truthfully about factual matters which will determine these proceedings. As I repeat, and Miss Robinson knows this, as I repeat, I have not done anything to prevent Miss Heard from giving evidence. I also draw the court's attention to the fact that Miss Robinson appears to accept that Miss Heard could, if she so wished and believes it is necessary to do so, seek the assistance of the California court. For the avoidance of doubt, if Miss Heard were to make an application to California court for an order allowing her to give evidence in these proceedings, I would not oppose any such application. In addition, the position set out by Miss Robinson, namely that Miss Heard feels bound by the confidentiality provisions of the agreement, it is inconsistent with various sly but unmistakable comments that she herself has made in the media after the date of the agreement. For example, November 25th, public service announcement on violence against women that Miss Heard produced and distributed on the internet with girl gaze, and which referred indirectly but unambiguously to her allegations that I had violently abused her. When it happens in your home behind closed doors with someone you love, it is not as straightforward as a woman having gone through this in a public stage, in a public arena. Now, as of writing this witness statement, remember this is dated after the op-ed on December 20th, op-ed in Washington Post titled, "I spoke up against sexual violence and I faced our culture's wrath." Miss Heard did not name me, but pointedly, unambiguously to the time period of her false allegations against me for the avoidance of anyone's doubt to whom she was referring and accusing. 2 years ago, I became a public figure representing domestic abuse, and I felt the full force of culture's wrath for women who speak out, and we know how the U.S. jury found on that. 7 people unanimously found that Amber Heard had lied and had done so with actual malice. So his witness statement is dated after this, but all the correspondence regarding Miss Heard having to testify was dated prior to her op-ed. Without any waiver of privilege, I have been advised that Ms. Heard's actions have for years breached the confidentiality provisions of the agreement. So apparently Johnny's lawyers have gone over things, and I would say this makes, with him saying this is what she's been doing and this is how it's alluded to her, to you, and we know that she's been a paid speaker for ACLU, for the UN, in various ways through what was the Harry Walker Agency at the time that was a spin-off of WME, who was her agency. They had a page for her for all her speaking engagements, and many of them were about women's rights, including DV. As far as I can tell, they have since dropped her since the ruling. I can't find it anymore. The application. It was not until service of the application that the defendants made clear that the release was limited to disclosure or communication that may be made to the defendants or their legal representatives for the purpose of these proceedings, and B, any evidence for the purpose of these proceedings. As I've explained above, the correspondence prior to issue of the application did not limit the requested release in any way. I have never stated that Ms. Heard is prevented by the agreement from giving evidence. On the contrary, it is Ms. Heard's lawyers who have apparently adopted that position. Ms. Heard did not want to testify. She either wanted to cause the son's side to be dismissed or she wanted Johnny to drop it. I understand that the defendants will be submitting that I am abusing the court's process. I find the allegation highly offensive. It is the defendants who have chosen to both publish and defend as true very serious false allegations against me. They chose to revive false allegations against me, knowing that there was a settlement between my ex-wife and I. By pleading truth, they are forcing me to give evidence about a matter which has been settled. I note that in a recent article published on the Hollywood Reporter website, it has been reported that my legal team had refused to allow Ms. Heard to give evidence and has even threatened to sue her for violating her NDA if she does. Copy of the article is attached. It is important to me that this misinformation is corrected. As far as I understand it, no such threat has ever been made, and my legal team has not refused to allow Ms. Heard to give evidence, which, if what Clementine is reporting is in Jen Robinson's book, is absolutely false. I wish to make clear that I have no concern about Ms. Heard being called by the defendants. My primary objective in bringing these proceedings is to ensure, as far as is possible, that other media outlets will not repeat similar allegations to those published by the defendants. I knew from the outset that there was a possibility, in the event that truth was pleaded, that this litigation would result in a trial involving determination of the facts in respect of the alleged underlying events. I find it insulting that the defendants are now trying to portray me as seeking vindication on a false basis. I do not believe that it was ever the intention of parties to my divorce proceeding that the agreement would prevent either one of us from suing third parties as opposed to each other for libel once the truth defense was put on the record. I was obliged to respond to the defense in my reply. I intend to give evidence of the facts pleaded in the reply. Prior publicity. Ms. Heard's allegations were never tested in the California court. There was, however, a huge amount of publicity about the allegations. Mr. C refers to this coverage in paragraph 12 of his witness statement, but does not make clear that much of that coverage was published prior to the agreement and or contained information which contradicted Ms. Heard's position. For example, the Variety article referred to in paragraph 13 of Mr. C's witness statement and exhibit contains a statement from law enforcement officials stating that investigation had found no evidence of an assault and that Ms. Heard did not want to file a criminal report. This article was published very shortly after Ms. Heard had obtained the TRO. The ET Online publication referred to in paragraph 14 of Mr. C's witness statement records that Ms. Heard had withdrawn her request for a restraining order. The Mail Online article referred to in paragraph 15 of Mr. C's witness statement. Now, Mr. C is for the Sun. Was published shortly after Ms. Heard had obtained the TRO and again included information from the LAP. The article by Io Tillett Wright, a witness for Ms. Heard in the U.S. proceedings, referred to a paragraph, Mr. C's witness statement and exhibit does not name me, although I accept that it relates to me. It was published prior to the settlement agreement. That was the one why I called 911. If I could not take action against articles that fairly and accurately reported court proceedings. Unlike the articles relied on by the defense, the Sun article I am suing on was published a long time after the agreement. It does not contain any denial on my part or the evidence which contradicted Ms. Heard's account, nor does it record that Ms. Heard withdrew the restraining order. It alleges that I paid Ms. Heard $5 million in respect to the DV allegations. For those reasons, I do not accept Mr. C's assertion in paragraph 12 of his witness statement that the articles listed above provide the context in which the Sun's article was published. The article was deliberately aimed at driving me out of the industry in which I have worked my entire life and wish to continue working in. I am confident I can disprove the defendant's allegations for the reasons set out in paragraphs 2.9, etc. And we know how that worked out, but I have more information on that. Comments to the press. At paragraphs 23 to 26 in his witness statement, Mr. C refers to the GQ article on Entertainment Weekly article. In reliance on those articles, he states that I am bringing this case to convince the world that Ms. Heard lied when she accused him of domestic violence. This is incorrect. My purpose in bringing this action is to stop false and defamatory publications. Ms. Heard's position. I have addressed the correspondence from Ms. Heard's lawyers above. Mr. C states in paragraph 32 of his witness statement that Ms. Heard has no desire to set aside the divorce agreement nor to become involved in legal proceedings in the U.S., which will involve further costs and publicity. This absurdity of this statement was shown on October 12th when Ms. Heard served notice of an arbitration demand dated October 11th that she hoped would be resolved by the Honorable Louis Messinger, retired. He is the arbitration judge that was assigned to them in their divorce. In a January 3rd, 2019 Hollywood article titled, I Was Petrified of the Monster, Johnny Depp, Amber Heard legal documents shed new light on the dual abuse accounts. Ms. Heard's lawyer, Eric George, disclosed the arbitration they were seeking as a desperate measure and inaccurately described both the issues supposedly at stake and the status of the non-existing proceedings. Mr. Depp's ongoing defamation and violation of the parties' confidentiality agreement is already the subject of pending arbitration. Conclusion. I do not believe it is fair or right that defendants should be permitted to defame me, plead truth, and then strip me of my ability to defend myself and defend my rights, because Ms. Heard protests that she cannot give evidence without breaching the agreement. If Ms. Heard believes that it is necessary for the agreement to be varied, she should address those issues before the California court. But for the avoidance of any doubt, I have taken no position as to whether Ms. Heard can provide evidence in these proceedings. And that's where it confuses me that, what's her name, Clementine, is saying that Johnny threatened to sue her. Oh, I want to bring this up. So this is what they're talking about with the GQ article. Johnny was required by Amber Heard's attorneys to provide any open cases or prior cases, and he did. This is the one that Amber Heard filed that is referenced in that witness statement. Purported arbitration demand. That's who the judge, it was arbitration that was filed. That's why we didn't see it. It was denied. It was inexplicably denied. And again, this all happened before the op-ed. And I really think that has a lot to do with why some of the things were said in the op-ed. I think she was greatly influenced by what was going on with the Sun's trial, with her having to give testimony, with her not wanting to give testimony and claiming the confidentiality and then twisting the words. And when all that failed, which it did, and she knew she was going to have to testify, she released the op-ed. Now she claims the Washington Post assigned the title, I Spoke Up Against Sexual Violence and Faced Our Culture's Wrath. This is the screenshot Amber Heard took. It is still on her Instagram account, and it says Me Too. And I know when I read it, I thought, oh my God, she's going to name the Weinsteins, etc., of what happened to her. And as I'm reading it, she only referenced 2 years ago what happened to her. I really think that this, the way I read it at the time was like, if you make me go through this, if you don't, this is my opinion only from reading this article, knowing what was going on behind the scenes. If you make me testify, you're going to be sorry. Anyway, let's go to what happened. So the Sun, I should take a break here. So the Sun filed to have the case dismissed. Johnny's case dismissed, saying, hey, he is preventing our key witness from testifying, therefore he should be dismissed. Johnny was saying, look, you were supposed to have all this information when you wrote the article, so I don't know why you need her, but I'm not stopping her, and I never said I would stop her. And Jen Robinson was involved in this communication, and now in her book she's coming out that Amber threatened to sue her. So I'm just trying to bring these facts. So there was a hearing in the UK with a judge who made a ruling. And this is all we have that's reported on it. Sun fails in bid to halt Johnny Depp libel action over the WB claim. Actor John Depp has fought off a high court bid to temporarily halt his libel action against the Sun over allegations that he harmed his former wife, Amber Heard. A judge sitting in London on Wednesday rejected the newspaper's application that his claim should be stayed unless and until the Star confirmed in writing that he would not sue Heard if she participated in the forthcoming trial. Mr. Justice Nicklin ruled that such an order was not necessarily at this stage of the case. He said the defendants, Sun Publisher News Group newspapers, and journalist Dan Wooten contended that Heard was a crucial witness for their defense, which is that the allegations are true. The Pirates of the Caribbean Star libel claim arises out of a publication of an article in The Sun last April under the title Gone Potty, How Can J.K. Rowling Be Generally Happy in Casting WB Johnny Depp in the new Fantastic Beasts film? Is this too small? I'm sorry, guys. Better. Mr. Justice Nicklin said the article concerned, and this is a different judge. I know Justice Nichols heard the trial, and Justice Nicklin heard the pretrial motion. So the article concerned alleged incidents of DV by Mr. Depp against Ms. Heard during their marriage. Depp's case, he said, is that the article bears the meaning that he was guilty on overwhelming evidence of serious DV against his then wife, causing significant injury and leading to her fearing for her life, for which the claimant has constrained to pay no less than $5 million to compensate her, and which resulted in him being subjected to a continuing court restraining order, and for that reason is not fit to work in the film industry. Well, none of this came out at trial because they argued about her not paying her enough, if anything else. And then Ed White, of course, testified that that was the negotiated amount they agreed to. And it was a TRO. He was not continuing. She didn't follow up on it. She dropped it. And this is one of the things that bothered me in Rottenborn's questioning of Johnny that caught him off guard. Why didn't you fight the TRO in the U.S. States? Why didn't you go to court? Ben, well, she dropped it. So there was no opportunity. Anyway. Heard considered she was subject to confidentiality restrictions in an August 2016 divorce agreement, which prevents her from assisting the defendant with evidence to support their case. But the judge announced, I am not satisfied on the current evidence that Ms. Heard's concerns about the restrictions that the divorce agreement imposes on her are well-founded. He that even if they were, the matter is capable of resolution. I know that sentence doesn't make sense. Mr. Justice Nicklin said Depp had stated clearly in his evidence to the court that he expects Heard may well give evidence in the proceedings, and he will not attempt to prevent that. So where is Jen Robinson getting off writing this chapter now if what Clementine is reporting is true? Because this is old news, and she was Amber Heard's UK personal counsel, was very much involved. We saw the statements in John's witness statement that she was corresponding. How could she not know this? He added, the fact that Ms. Heard presently thinks that there is some impediment to her giving evidence for the defendants has nothing to do with Mr. Depp. Even if she were right, there would appear to be a number of ways of resolving the issue that have not been explored adequately or at all. James Price, QC for Depp, told the judge during the hearing of the application that the actor had no fear of her giving the evidence at court. Depp, who denies harming Heard, would provide a raft of evidence from independent witnesses who fundamentally contradict the evidence given by Miss Heard, said Price, which he did, which Nichols decided he was going to discount all of it. He said the actor wants to stop false and defamatory publications. Adam Wolanski for the defendants told the judge that they had pleaded a defense of truth and said Depp alleges that it was Heard, not him, was the aggressor. The judge said whether the allegations of DV are ultimately proved true is a matter for a trial. At this stage, the court is not in a position to and does not make any findings at all. No date has been set for trial at this time. So the only one preventing Ms. Heard from testifying at this point is Ms. Heard, without a doubt. Now, what's come up a lot, and I figured I'd bring this up, is, and I find this interesting because there is a Mr. Price, James Price, that's for Depp, and there is a Price that represents Amber Heard. But anyway, this was the hearing where there was some audio tape that was being brought into the UK trial that was pretty much inaudible, and it was from San Francisco, and Amber Heard was cherry picking snippets of it. And rightfully so, David Sherburne, Johnny's QC, said, hey, this isn't fair. We want the whole tapes, not just the snippets. And this was the ruling on that, sadly. She comments, Mr. Sherburne submits that the exchange is relevant. Ms. Heard possesses the recording. Its production to the claimant, at paragraph 39, is necessary to dispose fairly of the action. Ms. Afia, also Johnny's attorney, comments that at one point in the recording, Ms. Heard begs the claimant to hug her. Mr. Sherburne submits that this is inconsistent with Ms. Heard's account, which has been adopted by the son, that he had subjected her to repeated and serious violence. Ms. Afia also comments that the recording is also inconsistent with Ms. Heard's allegation of one particular incident of alleged violence. That would be the headbutt. By the claimant on the night of Ms. Heard's birthday. Oh, sorry, April 21st. The claimant's pleaded case is that he was the victim, not the perpetrator or DV. Ms. Afia says in the recording, the claimant alleges that it was Ms. Heard who hit him. Ms. Afia says that on the recording, Ms. Heard does not deny this version. Now, we know that, unfortunately, Judge Nichols ignored all of the audio. He refused to take any of it other than outside court utterances having no importance, except for the one statement about the headbutt. That's the only thing he allowed. And sadly, the rest of that statement says, from Ms. Heard, I didn't think you realized you did it, which was not intentional. Mr. Price QC, who represents Ms. Heard on this application, argues that this category does not satisfy either of the necessary preconditions of, and this is basically about discovery, forcing witnesses to provide information. The Judge Nichols rules, I agree with Mr. Price that the claimant has not shown that this ruling, which is discovery of witnesses, is satisfied. In my judgment, the evidence from the claimant does not establish that Ms. Heard is likely to have a better copy than the one that's been produced. It's only if she did that it could even arguably be said to be necessary for fair disposal of the case to order her to produce it. Mr. Depp can, of course, give his own evidence about what is said in the recording. And if the quality of the recording is poor in places, as Ms. Afia says, its value in rebutting the version will be diminished. Yeah. Basically, it was open to interpretation of the muddled words of who wanted to say what or believe what. This is what's important. I refuse to order Ms. Heard to disclose Category 1A. Mr. Price said that Ms. Heard has offered to investigate whether she does have a better recording and to produce it to the parties if she does. Yeah. That may be helpful, but it does not alter my view that the claimant is not entitled to an order to do so. And he does this over and over, and he refuses to require that Ms. Heard must provide evidence. I refuse to order Ms. Heard to disclose in that category. I refuse to order Ms. Heard to disclose in this category. It goes on and on. Accordingly, I do not accept a precondition. For the same reasons I've given, I refuse the part of the application he refused over and over and over to require Ms. Heard to provide any discovery. So the only thing I had left to cover, I hope I can make this bigger. Let's see if we can, this is what we've heard about a lot, the confidentiality clause. It's going to hurt your eyes. I'm going to do the best I can. This is all we have that's made public. And this was made because Amber Heard submitted her divorce settlement into the April 11th filing 2019 as part of her declaration. This is what Johnny Depp refers to in his witness statement. This is what the son has been referring. This is the only confidentiality notice that we have. Except for documents previously filed with the court, neither petitioner nor respondent, neither Amber Heard nor Johnny Depp, shall discuss, publish, or post or cause to be discussed, published, or post directly or indirectly any information pertaining to the parties' premarital relationship, marriage, or this dissolution's action on the internet, including but not limited to social media applications, websites, blogs, news periodicals, etc., or in the media in any manner. Petitioner and respondent shall also instruct their respective agents, friends, family members, and representatives not communicate and or act in any way contrary to this provision. Now, I know we always say, but people have been doing this on the internet like I.O. They can't restrict his free speech, but she can openly, she could say, look, stop doing this. Please don't do this. I don't support this. But they can't really stop people from doing things outside of this agreement. The confidentiality provisions set forth herein shall be fully enforceable by each party. The parties each expressly acknowledge and agree that the confidentiality provisions in this judgment are of special, unique, unusual, and extraordinary character, and that a breach of any confidentiality provision of this judgment shall necessarily result in irreparable injury to the other party for which no adequate remedy is available at law, and which is not fully compensatable in money damages alone. The parties further acknowledge and agree that in the event of any such breach or threat thereof, the non-breaching party may be entitled to injuncture and any other equitable relief as may be necessary to prevent, remedy, and or mitigate the adverse effects of such actual or threatened breach, in addition to any legal remedies such as disgorgement of profits received or damages to which said party may be entitled. The parties acknowledge and agree that the non-breaching party also shall be entitled to seek recovery of any and all reasonable attorney's fees and costs incurred to pursue such remedies. Now, we know Amber Heard tried to do this with the GQ article. We saw that. She went through the arbitration as this required, and she was denied. Each of the parties hereto acknowledge, agrees, warrants, represents, and covenants that, except as may be required by law, and this is what Johnny was referring to, each said party shall refrain from making or causing to be made, and agrees not to be made or caused to be made, any derogatory, disparaging, critical, or accusatory statements, either directly or indirectly, express or implied, oral or written, concerning the other party, whether said statements are believed to be true or not. The foregoing shall not be construed or enforced in manner that would restrict the disclosing party from responding truthfully in response to any inquiry required by the legal process. So that's the excerpt I pulled out to just give you some basis on what's going on with Johnny's statements. So he never in any way whatsoever intended or attempted or threatened to sue Amber Heard from testifying. And I don't know why Jen is stating this in her book, although I don't have access to her book, so I can't quote her. I can only go by what her friend is claiming. And that's all I've got. And this is who she is. And I think it's important to restate this. We had heard her claims. I can't get access to the book. And this is what she's claiming again. Now, she talks about in this chapter, another detail, she talks about the chapter in general, that Jen Robinson has included a chapter referencing the Depp versus Son in general. And then this is what she's saying again. So after I've presented the evidence, the court documents to you, now how do you feel about these statements?
Another really interesting detail in this chapter is because Amber Heard had signed an NDA during the divorce proceedings with John Depp. And also it's important to note that aside from her restraining order against him, she had never mentioned him publicly. She'd never spoken about the abuse that he subjected her to. She did write an article about being a survivor, but he was not named in it. And because she had signed that NDA, she was technically prevented from giving evidence in the UK libel case against the Sun newspaper, the case that John Depp brought against the Sun newspaper, that she needed to get around the NDA to offer evidence to support the court. But she didn't really want to. It was essentially the same situation as Erin Jean Norval here, where the Daily Telegraph published her story without asking her, and she was forced to speak against Jeffrey Rush publicly. So to put this in terms that I understand, not being a lawyer, because Amber Heard had signed an NDA at the occasion of their divorce, and then the Sun newspaper had then printed an article calling him a wife beater, which she had never said publicly. All she had was a restraining order against him, but she'd never labeled that allegation against him publicly. He brought that libel case against the Sun, but he refused to release her from her NDA, which would enable her to testify in that case, which meant that if she hadn't fought against it for the right to be able to testify, he could have won on the basis of it being just the newspaper's word against his, which means that she could have then been publicly branded a liar because he would have won his libel case despite the fact that he refused to allow her to leave the NDA in order to testify. And had she not fought for the right to do it and just done it anyway, he could have sued her in American courts for being in breach of that NDA.
Not according to what he said. Right? Now, how do you feel about that? Since I have presented Johnny's side. And again, this person, I don't have the book. I don't have access to the book. I can only go by Jen Robinson's. She has retweeted this, that Clementine Ford will be in conversation to bring this book tour with Jen Robinson on this particular day. She appears to be quoting or referencing the book. I don't have access to the book. I can't say exactly what Jen Robinson has quoted in it regarding this. I can see by Johnny Depp's statements that there has been correspondence well early on before this book was ever dreamt up, that she would have knowledge of what was going on. So I just wanted this to come out and say, look, here is the case that the Sun tried to get it dismissed on her, Johnny refusing to allow her testimony, and Johnny's statement saying that didn't happen. And the judge ruled in Johnny's favor, saying that he never caused Amber Heard at all not to be able to testify by the NDA. So I just wanted that out there. So I hope you all are good, doing good today. And so that's the information I have for today. So you have to make your own opinion. But I'm just shocked that this is being reported. And I do understand this does happen with these NDAs. And I do understand why they're being ruled out, that you can't use them anymore. I do understand Weinstein used them. But in this case, very early on, Johnny went on record and the judge agreed that he was not threatening Amber Heard in any way. So I hope this is informative. I hope everything goes well for you today, and have a great one. Thanks. Bye-bye.